When young Dolph died, his family told the probate court they could not access all of his financial records and business accounts. An early filing estimated approximately $250,000 in known personal property, but made clear that the true value was still unknown. 4 years later, the estate reported nearly $7.7 million on hand, and during just one of those years, more than $4.2 million reportedly came into the estate from royalties. But locating and protecting that money was far more complicated than anyone expected. The probate records show that young Dolph died without a valid will. They show that Google had to be ordered to release the contents of his accounts because the administrator reportedly had no passwords or digital access instructions. They also show repeated court warnings over late and incomplete paperwork, including one serious question about a $2.7 million checking account. So what was young Dolph's estate actually worth? Where did the money come from? And did the court uncover financial misconduct? Or was it trying to force the estate to produce the accounting required by law? I went through the documents, and the real story is not simply about how much money Dolph left behind. It is about how difficult it became to locate, account for, and protect the empire he built. Young Dolph's legal name was Adolph Robert Thornton Jr. He was killed in Memphis on November 17, 2021. Less than a month later, a petition was filed in Fayette County, Georgia, seeking authority to administer his estate. That petition states something important. Dolph died without making a valid last will and testament. In legal terms, he died intestate. The documents identify his two minor children as his heirs. Because they are children, we are not displaying their addresses, birth dates, or other private information contained in the paperwork. The petition identifies Dolph's fiancée and the mother of his children. She asked to be appointed administrator of the estate. The court also appointed a guardian ad litem, an independent representative whose responsibility was to protect the interests of the minor heirs. In April of 2022, the judge officially appointed as administrator and required an initial bond of $250,000. Think of that bond as a form of insurance protecting the estate. It is not an inheritance payment, and it is not automatically the same as the estate's value. That $250,000 bond was based on the limited information available near the beginning of the case. At that point, the people handling Dolph's estate were still trying to determine exactly what he owned. An early amendment estimated approximately $250,000 in known personal property. But that same filing explained that did not have access to Dolph's actual records and financial accounts. It said the information would be updated after access was obtained. The guardian ad litem's filing made a similar point. The complete value was unknown because some of the money had been held separately by Dolph. This is an important distinction. The documents do not show that Dolph's entire estate was originally worth only $250,000. They show an incomplete early estimate made before the administrator could see the complete financial picture. And gaining access apparently became a major obstacle. In February of 2023, asked the court for more time to file the estate inventory. According to that motion, she had been unable to obtain accounts and documents connected to Dolph's companies and business interests. The filing even said litigation might be necessary to acquire the records. Imagine trying to reconstruct a multi-million-dollar entertainment business without immediate access to its accounts, passwords, and internal documents. That is essentially the problem described in the court filings. The digital side of Dolph's estate created another obstacle. In December of 2023, the administrator asked the court for help accessing several Google accounts held solely in Dolph's name. The motion said she did not possess the passwords. It also said Dolph had not left instructions explaining how those digital accounts should be accessed after his death. The filing described their contents as potentially important to locating and protecting estate assets. In February of 2024, the judge ordered Google to disclose the accessible contents of those accounts to the estate administrator. But the court order itself revealed something bigger. Dolph had created valuable businesses and intellectual property, yet some of the information needed to understand and manage those assets may have been locked inside accounts that nobody else could legally access without going to court. While the administrator was working to locate the estate's records, another problem developed. The estate inventory was late. In July of 2023, the probate court ordered and the bonding company to appear and explain why it had not been filed. The citation warned that failure to comply could potentially result in her removal as administrator. Shortly after that citation, the inventory was submitted, and it revealed the first major amount of money. The inventory listed a Bank of America checking account containing exactly $2,717,383.63. It also listed interest in Paper Route Empire LLC and Paper Route Touring LLC, but the values of those companies were marked to be determined. That means the $2.7 million was not necessarily a complete valuation of Dolph's estate. It was the amount disclosed in one checking account, while the value of significant business interests had not yet been determined. After receiving that inventory, the court raised the administrator's bond from $250,000 to approximately $2.7 million. As the amount under administration increased, the financial protection required by the court increased with it. Then, in April of 2024, the probate court issued its strongest warning. The citation said the inventory had been filed approximately 1 year late despite the court granting extensions, but the judge also raised a more serious accounting question. According to the citation, the $2,717,383.63 checking account disclosed on the inventory had been omitted or had not been accounted for on the annual return presented to the court. The filing also said had not responded to questions contained in a March 6 court letter. The judge ordered her to provide a full accounting and appear at a show cause hearing. Again, the filing warned that she could potentially be removed. That was a serious demand for an explanation. But here's the distinction that protects the accuracy of this story. These records show filing delays and accounting questions from the court. They do not contain a judicial finding that stole the $2.7 million, committed fraud, or intentionally took money from Young Dolph's children. The issue documented in the citation was that the account had not been properly reflected or explained on the annual return. Revised and supplemental returns were later filed, and the court allowed them. One return covering 2023 reported that the estate had approximately $3.38 million remaining on hand. A supplemental return covering the first 4 months of 2024 placed the balance at approximately $4.2 million. The judge then increased the required bond again to approximately $4.2 million. Instead of reading every intermediate figure, look at the overall progression. As more assets and income appeared in the accounting, the court required more protection. But the biggest increase was still coming. A return filed in 2025 reported approximately $453,000 in royalties received between May and December of 2024. After reported expenses, that return listed approximately $4.24 million remaining in the estate. The judge allowed the return in March of 2025. Then the annual return covering 2025 revealed just how valuable Dolph's music continued to be after his death. According to that return, the estate received $4,261,300.48 in royalties during that 1 year, more than $4.2 million in royalties in a single year. The return listed approximately $813,000 in total disbursements, including professional fees, household costs, travel, and expenses connected to the children. After those reported expenses, the estate listed a remaining balance of $7,689,748.97. That is the number behind the $7.7 million headline, but it needs to be described correctly. This was the reported balance on hand in the probate estate. It was not necessarily a complete valuation of Dolph's companies, trademarks, future royalties, unreleased music, or every asset connected to his legacy. And it was not necessarily money that had already been distributed to his children. The estate was still being administered under court supervision. Before that return was filed, the court had issued another citation in late 2025, followed by an amended citation in January of 2026. The docket uses broad language referring to failure to make returns or alleged mismanagement, but the actual citation identified a narrower problem. The annual return was overdue, and the administrator allegedly had not responded to 3 court notices. It did not identify a new act of theft or claim that another account had disappeared. The overdue return was subsequently filed and allowed by the court on March 3, 2026. That same day, the judge increased the administrator's bond one more time. The previous bond was approximately $4.2 million. The new order raised it to $7,689,749, essentially matching the assets reported in the annual return. The administrator later requested additional time to obtain the larger bond, explaining that underwriting millions of dollars in new coverage could take longer than expected. And that leads us to the latest major proposal in the court file. In July of 2026, proposed placing $4 million of the estate into a restricted account managed through the investment firm William Blair. Under the proposal, money in that account could not be withdrawn, transferred, pledged as collateral, or otherwise used without a certified court order. The request appears designed to place a substantial portion of the estate under an additional restriction while reducing the amount that needed to be covered by the administrator's bond. Because Dolph's heirs are minors, the judge appointed a guardian ad litem to examine the proposal and represent their interests. However, the documents we reviewed do not include a final order approving or rejecting the plan, so we cannot say the $4 million has already been transferred or locked away. What we can say is that the administrator requested the restriction and that the court appointed someone to evaluate whether the arrangement would protect the children. And that brings us to what these records actually reveal. Young Dolph died without a valid will. His family reportedly did not have immediate access to all of his financial records, business documents, or digital accounts. The estate faced repeated delays and court warnings while those assets were being identified and accounted for. But Dolph's music continued generating millions of dollars. The reported probate balance ultimately grew to approximately $7.69 million. And the court increased the administrator's bond to match that amount. The biggest story here is not a proven theft or a court finding of fraud, because the records we reviewed do not establish either one. The real story is that Dolph built an empire capable of generating more than $4 million in royalties during 1 year after his death, but he apparently left no valid will or complete digital access plan explaining how that empire should be handled. Building wealth is one thing. Making sure the people you love can locate it, control it, and protect it after you are gone is something completely different. And for Young Dolph's 2 children, that process is still unfolding in probate court. What surprised you the most? That Dolph did not leave a valid will? That his family reportedly needed a court order to access his Google accounts? Or that his music generated more than $4.2 million in royalties during a single year? Let me know below, but keep the conversation respectful because 2 children's inheritance is at the center of this case. And subscribe for more document-based stories where we separate what the paperwork actually proves from what people are claiming online.